try to keep some of our, feel a little bit more like the way that it usually goes. Why don't I hear from defendants just on the fee,
Okay.
and then we'll be done with all of our affirmative presentations. And then
Okay.
Is that all right?
Okay, that is fine. And then, well, there's one thing I was talking about, but I can do.
Okay, thank you. Counsel for defendants, any comments on the fee?
We take no position on fees.
Mr. Kittle, any comments on the fee?
Appreciate Your Honor allowing us to respond on the fee issue. The court is of course familiar with the Sugarland factors, the benefit achieved, the contingent nature of counsel's fee, and the efforts of counsel and time invested, the complexity of the litigation, and standing and ability of counsel involved. I have no issue with the ability of counsel involved. I have a lot of respect for them. There's no issue with that. My challenge here is with the benefit achieved. The benefit achieved is miserable. You get a $129 million settlement is what they're arguing, but you only get to that by allowing a $1.4 billion wrong. It's a loss of $1.3 billion. That is not a good result. That is not what people wanted. That's not what the class wants. That's not what I think is what was bargained for. When people say, okay, well, class counsel can bring claims that somehow benefit the class, that's not a good benefit. That's not that first factor is an absolute fail. Second, the contingent nature of counsel's fees and efforts of counsel and time invested. I take contingent litigation on. I take it on quite a bit. I don't understand how this is, and Mr. Lebovich's firm does a lot of contingent litigation, probably a lot more than I'll ever see in my entire life. There is nothing to that factor right there that should support any sort of upward claim on what's going on. The complexity of the litigation, that comes with practicing in this court. These are hard issues. Yes, it is a hard issue, but there wasn't something hard about actually going through and taking some depositions. There 59,000 pages of documents, that was it? No, it doesn't support a $20 million fee. It doesn't support a $20 million fee. I find the fee offensive compared to what was achieved for the class. My view on this has been made out pretty clearly in the objections that we put forward, Your Honor. We suggested, and I think it's time that people start looking at this, we suggested that the consideration that plaintiff's counsel should receive is exactly what they're getting for the people involved. Their interests will be totally aligned. Let them get stock. If they want to get this, let them get the stock. My view on there, too, is that I think that that's probably driving a lot of the concern that people are raising, is that there is a party, plaintiff, who owns 32 shares, who comes in, completely blocks everyone else from trying to bring their own claims. I'm faulted for not having jumped ahead. Everybody has seen the mad rush that goes on with respect to a lot of these claims at the courthouse. We're faulted for not rushing in and bringing something. My view on this is that when you've got ultimately a law firm that is going to be a plaintiff's law firm, and they're going to argue on behalf of stockholders, they should be prepared to take it when people are upset because they thought they did not get the job done.
Hold
lot of people that are upset. And that's fair. That criticism is fair. Nobody wants the online abuse. Nobody wants to be concerned. I've been in cases where I've been had a lot of people where I've been had concerns about safety issues and that sort of thing. That's not acceptable. But to be upset about being criticized when you're walking away with a $20 million fee after everyone else is losing their life savings, no, that's just disappointing. That's just disappointing. Your Honor, I don't think a service award is merited. And I'm not one to stand up and block. I've been in this court seeking fees for contingency litigation. I'm not one to do that. That's not my practice. That's not what I do. I know that I've been, people, talked about my co-counsel and everything. It's just not fair. It's not appropriate. It's not fair. It's not right. My co-counsel and I both clerked in this court. Mr. Lebovich clerked in this court. We know what this court means to us. And I'm here defending people that are not able to stand up today. I'm standing up for those people. And I'm doing it because I want to make sure that they have a voice in this court. $20 million, no. That I object to that settlement, that payment of any fee on this. So, thank you, Your Honor.
Thank you. All right, here's what I would propose. I know we've had a lot of fits and starts, and I do appreciate everybody's patience with the flexibility that's been required today. We have several more pro se objectors on the calendar for tomorrow in time slots that they've gotten advance notice of. So what I would propose, and then, I would think that rebuttal would be most useful once we've heard all of the objections. So what I would propose is that we recess for today, come back tomorrow. We'll take roll in the morning and see who's available to speak and make game time decisions as we did today, and then I'll hear rebuttal on all points from counsel. How does that sound? Thank you very much.
All right, I guess that's it. Listen, I just opened up because there was silence in Matt's, so I hope nobody takes it the wrong way. I'm just going to shut it down and then we'll jump into whoever's holding a room.